So you are here for Medicaid Jeopardy, although you're not expected to answer questions in a question format. So I won't be exposing you to that. I did think about at one point doing like a big EPS DT for 400, please, but I didn't have that level of motivation. So. Because I will tell you, I am a new grandma, and I spent the last week in Kansas with my new grandbaby. And she's amazing and wonderful and very special. And her name is Esri. For those of you who are Star Trek nerds, she's a minor Star Trek character. Good. If I had chocolate, I'd give you some. Yeah, she was a Dax. So now all the important things have been said. You guys can leave. I'm Nancy Wright, and I'm a private attorney in Gainesville. I worked for legal aid for some years, and one of the biggest parts of my work there was a Medicaid grant related to the Agency for Persons with Disabilities, and I unintentionally became an expert. And then decided I really liked that, and there was an awful lot of need for those of you who are even remotely familiar with Medicaid, you know how difficult and complex it is and sometimes hard to get the services that are needed. And when that grant funding ran out and they weren't going to do that work anymore, I went into private practice, which everyone told me was impossible to do. But guess what? It's not. If you work out of your house and don't have an overhead and your husband helps you with all your financial stuff. But I love it. I love the work that I do. I like working with the different areas of law, which is pretty exciting. You know, it's one big gloppy mess of laws and regulations, but you work in administrative and rules and lobbying sometimes, and federal court, and occasionally I'd even do stuff in state court. So it's got a wide range of opportunities. So all of you are here because you have braved the Medicaid questions, and probably because you've been experiencing problems with getting Medicaid for your kids. And I asked for the people to submit some questions, and so I'm going to kind of go through those, and then I'm going to step down here and take some other. Why don't we do that first? Because I have questions that relate to the different types of Medicaid, the differences in services, if any, private health insurance, a lot of questions about problems with providers, and some questions on the waiver programs. But let me take other questions that you might have, and I'll try to weave them in when it makes sense in the narrative. And then also, I really want you, if you're like, what the heck did she say? I don't understand that. Or you have a follow-up question, just wave at me or yell at me if I'm not paying any attention to you, because I think it's important. I want to try to make this a back and forth as much as possible, because I know it's confusing, and even if I try to explain it well, there are lots of other questions that are going to pop in your heads. So does anybody have any questions that they came in with that you didn't write down? Paolo.
So wait lists. When is the state allowed to have wait lists, and when is the state not allowed to have wait lists on Medicaid?
Okay. When can you have them?
Yes.
Okay. Anything else? Any other questions? Okay, all right. Oh, yes.
This is really specialized, so it may need to wait until after. Do you know about waivers available to disabled children who are also, disabled young adults who are in extended foster care, but they are not American citizens?
They are not what?
American citizens.
Oh, waive anything available to not American citizens. This may actually involve me looking something up later, or someone else in this group might have a good answer for that.
And I understand
No, but you run across it a lot. Yeah, I know that's a problem. In the back?
How do you access respite and other Medicaid programs for children who are on like med waiver?
How do you access your the?
Additional respite, other than what they med waiver.
Oh, additional respite. Okay. Anything else? Okay, I'm going to try to weave those in, but like I said, ask questions in between. Okay, I'm going to start off giving you kind of a, why are there so many types of Medicaid and why is it so confusing? Okay, I don't know why it's so confusing, but I can tell you why I can tell you what how I have done the breakdown. I don't know how anyone else does it, but this is how it makes sense to me. Yes.
Do you have any materials that may not have made it to the app?
No, I just have that app, the kind of question and answer that it's on the app. Okay. So I break down Medicaid into 3 different categories, and each type of Medicaid meets one of these 3. So the first is to break it down by the type of service that's offered, and essentially that's 2 categories. It's either services that are offered through something called state plan Medicaid, or services that are offered through a waiver program. And the difference between the 2 is pretty extreme. A state plan Medicaid. So what happens is Medicaid is a federal program that the state administers. The state pays for part, and the feds pay for part. So you have to comply with the Federal Medicaid Act currently. We don't know what's happening later, but currently you have to comply with that act. And in order to do so, you have to submit something to the feds that say, here's how I'm going to administer the Medicaid program. That's called the state plan. And what that refers to is all of the things the Medicaid Act says that you have to provide, the mandatory services like hospitalization, and all of the things that are optional that you decide to provide. Everything on the state plan has to be available to every person who qualifies for Medicaid. And there is no cap currently on the number of people who can qualify for that. If you meet the criteria, you get Medicaid, you get services. Okay? That's the state plan. A waiver is a program that actually one of the questions is what is waived with a waiver? And what is waived is the feds say, we won't make you meet one of these 3 different requirements of the Medicaid Act. The first one is comparability. And that is a requirement that says if you're on the state plan and you need these services are medically necessary for you, we can't decide you're not going to get them because you have some certain diagnosis or you're some certain age or whatever. All those services have to be comparable across categories. The second thing that they can waive is, this is a word they use, I'm not making it up, statewidedness. And that means that you can't not offer services in Pensacola that you offer in Dade County. The third is freedom of choice, and that is allowing you to pick whatever providers are available under Medicaid. So a lot of you think of waivers as just being the waivers that offer home and community-based services to a certain defined category of people. That's what the APD waiver is. And there's a whole category and requirements for home and community-based services that are in the federal regulations. That is waiving comparability. Because what you've done is you set a certain category of and definition of people that are they're the only people who are going to get these specialized services that they can allow them to stay in the home. Every one of the home and community-based service waivers, and there are a number of them in Florida, have a requirement that is federal that says that the people that are eligible for this program are otherwise meet the level of care of an institutional placement. An institutional placement is a state plan Medicaid service. So essentially you've got, and no one likes to use this word, but you've got an entitlement to institutional placement if you're on Medicaid and you have to be in a nursing home or you have to be in an intermediate care facility for people with developmental disabilities. You don't have to, there's no waiting list. That's the big issue here. State plan, not supposed to be any waiting list. Has anyone out there had problems getting behavioral services for kids with autism? There's a big issue with that. That is a state plan service, but they don't have enough providers. And there are ways to deal with that on a federal level that are really annoyingly difficult. Which is why it probably hasn't been dealt with sooner. The Agency for Healthcare Administration is doing a lot right now to try to break that logjam, but that shouldn't happen. You should not be waiting for services if you have a state plan Medicaid service that you need. And because one of the requirements of the Medicaid Act is that you have to be provided with medical assistance with reasonable promptness. That's not defined. Case law defines it, though. You can look at cases that talk about it's circumstantial. Like if it's an emergency service, it may be days, but otherwise, 30, 60, it depends on the cases you look at. So a lot of you have probably waited way longer than that. That's a violation of reasonable promptness. So you've got these two different types of Medicaid that are based on the services, essentially. One is state plan, one is a waiver. Then you've got two different home and community-based service waiver. Okay, the second way that you look at Medicaid is how the providers are selected and paid for. And once again, you've got the typical standard, which is fee for service. That's, I go to a provider, there's a fee for that, and ACA pays that fee, and that's bada boom, bada bing, that's it. The other option here is managed care. Now, because managed care operates in a way that has its own contracted network of providers and you're not supposed to go out of network, that is a restriction on freedom of choice, right? So in order for managed care to operate, every state has to apply for a waiver of the freedom of choice part of the Medicaid Act, which Florida has done. So all managed care is also a waiver, but you don't need to worry about that. There are a lot of regulations that apply specifically to managed care. There's a contract between ACA and managed care organizations that's online, which is delightful to read. And there are different rules and regulations that also apply to managed care now that didn't. I did a big federal case involving one of the big waiver programs that's in managed care, and there are a lot of things that are happening in that regard. So I can talk a little bit. How many of you have kids that have dealt with Sunshine Health, which is the children's, okay. And what about CMS? Do you have kids that are in CMS? Does anyone have kids that are in the Magellan specialty care program? And that's for behavioral services. And do any of you have kids that are just straight fee for service? Okay. So those are the options that are now, I think, if I've left anything out, maybe if you have kids that have AIDS, there's a specialty plan for that. There is. So that's the second category, is how the providers are how you get providers, how they're paid. The third category is who is eligible, and that's where you get the distinction between someone who is on Medicaid because they get SSI, someone who's on Medicaid because their family or household qualifies based on income, and you're a child. And also pregnant mothers will get Medicaid through what's called family-based. Some people who get Medicaid because they're enrolled in a home and community-based waiver program. That's a separate category. And the same criteria applies for people who are institutionalized. All of these have different eligibility criteria. And then you've got separately child welfare. Okay, so we've got those three different things you have to think about whenever you look at whatever Medicaid some kids got. In the dependency world, you're probably dealing with Children's Medical Services. They have a network of providers, but unlike the other managed care, unlike Sunshine Health or Magellan, those are fee-for-service payments. It's a weird amalgamation of fee-for-service and a type of managed care. Sunshine Health and Magellan, those are both paid a per capita amount per child, and then they get that glom of money and average it all together, and supposedly it all works out great and everybody gets what they need. Are there differences in services? So theoretically, no. You're not supposed to have any of those plans except for the home and community-based waiver plans. For a state plan, you're supposed to be getting the same level of services, the same type of services, regardless of the plan that you move to. And as a practical matter, the distinction is more based on providers. So for CMS, for instance, a lot of families, there are providers that are enrolled in CMS that deal with children with complex medical needs, and they don't enroll in any of the other programs. They're not licensed under any of the other programs. So a lot of families are devastated if they get chunked out of CMS because they've got these specialized providers that they've had for forever that they trust. Sunshine Health has its own network of providers, Magellan, its own network of providers. All of them have the option of contracting for an out-of-network provider. Has anyone had that occur with any of their kids where they got an out-of-network provider? I'll talk about that a little bit more when we talk about provider issues. So what happens if a child has both Medicaid and private health insurance? This is an issue that is called coordination of benefits. In my experience, there's not much in the way of coordination, and there's no system developed to coordinate. It's kind of a case manager thing that they're supposed to do, and you have case managers that often have no understanding of how to do it. But Medicaid, so there are different levels of insurance and who should pay. So at the very bottom, the payer of last resort is the Medicaid waiver program. You got to try to get everything you can from every other source before you get the Medicaid waiver program. That includes state plan Medicaid or Medicaid from Sunshine Health, that level of care. Okay, so they're the next ones up. And then, but they make you go wherever you need to go to get insurance. If you have private insurance or Medicare, and some people do, you have to go there first. Now, there are a lot of problems if you know that you can't get a service through your private health insurance, and they won't even issue a denial because it's not covered, it's in their handbook. Often there's a lot of delay because Medicaid is saying, we need a denial, and you're like, they're not going to give me one. It's not offered in the handbook. I've used it. I've just sent a copy of the handbook and highlighted the page that shows it's not a covered service, and been able to push Medicaid to do what they need to do. Has anyone had issues with coordination of benefits?
And Nancy, can you go over that? I'm still a little bit confused on that whole topic. So how's it practically work? Does the parent, like in the case I'm involved in, the child, they have Medicaid and they have a private HMO. And it's a therapeutic service, a special type of speech therapeutic service.
Uh-huh.
The private HMO would not cover it. And so they apply for Medicaid, and Medicaid said the HMO should cover it. So how's that? It seems like they go back and forth.
Well, so this is a theme, isn't it, with the state of Florida and services, is that everyone's arguing someone else should give it. If I have a denial letter from the HMO and I send it to Medicaid and they say they won't provide the service because the HMO should provide it, I just kind of go mini ballistic and say, you know what, you need to figure that out with the HMO, because the service is medically necessary for the child and it needs to be provided with reasonable promptness. So if you have an issue, you need to talk to the HMO. And the same is true with school services. I mean, Medicaid won't pay for a lot of things if the school is supposed to provide it. Well, we all know, and anyone who's dealt with schools knows, that there's a wide range of disagreement on what kind of services children with disabilities should get in school and whether they are, quote, an educational benefit or not. So they won't provide a lot of behavior services or therapies because they don't think it's an educational benefit. And then Medicaid says, well, the school should be providing it because it's an educational benefit. And who's left in the middle is the child. So I once again, my only line of defense here is we have a denial. We have the kid is not getting the service in the school. We've proven you that that's true, and it's medically necessary. Agree or disagree on medical necessity, and we'll go to hearing on it. If not, it's a reasonable promptness claim, and you can use. They don't like right now. I think the only truly effective thing to have in your weaponry is a potential federal action, because I have not had great success in other levels. If you go to a hearing and you lose, you go to a district court of appeal. You've got a high standard that's no competent substantial evidence. It's very difficult to get through on the limited issues that the court will look at. But the federal court can look at the Medicaid Act, and they do, and with a certain degree of seriousness. So I think it's important that you know that's there. Not just the Medicaid Act, but also the Americans with Disabilities Act. And, read the Olmstead case again, because so many times we're working with kids where they're being limited in their services to such a degree that you don't have a choice but to end up putting them in a residential facility or someplace that, we just heard that great talk about wraparound services. Well, wraparound services are part of is anyone familiar with the Rosie D case? Look at that one too, because that was a case in Massachusetts arguing that children needed wraparound services to be able to stay in the home, which means very intensive behavioral programs, whatever's they'd get in an institution essentially, under the Medicaid Act requirement that you provide EPSDT for children. How many of you know, anyone know what EPSDT stands for? So there's mumbling in it, but it sounds like they're words that are close. It's early and periodic screening, diagnosis, and treatment, which doesn't sound all that cool or fabulous, right? You know, and plus it's way too many letters for a decent acronym. In another conference, I was the only reason I ever remember it is because of this. I was told to remember Nixon. When you think of this, every president should destroy tapes. So, but that EPSTD is a powerful thing to know about in the Medicaid Act, because essentially what it says is if you've been diagnosed with a condition, then you get what is necessary to correct or ameliorate that condition, regardless of whether or not those are services that are offered to adults. So in Florida, for instance, there are certain services that may be offered to adults, but they're super limited, like physical therapy for an adult. That's essentially just a wheelchair fitting. Very limited cap on the number of the service. You can't do that for children. You have to give them what they need. You can't cap it. You can't say that service is not available to him or her. And that's how, so in Massachusetts, that was applied for wraparound services. In Florida, which has been particularly reluctant to use EPSDT in a broad way, there are cases that said it applies for consumable medical supplies like diapers, and the big one is applied behavior analysis services for children on the autism spectrum. That case was, I think, a 2010 federal case. The judge issued a ruling from the bench and said that within 6 days, the Agency for Healthcare Administration had to implement applied behavior analysis services. There was a lot of activity at ACA over that period of time. And so the result has been, it's been offered, but of course the level of need is not anywhere near the level of providers that are available, and that's where we are right now on that. I've lost my train of thought. Please, every time I do a Medicaid talk, I say please remember EPSDD if nothing else, because that is a powerful tool in your weaponry, and also can be the topic of a federal case. I'm not suggesting you all run out and do federal cases, but there are a lot of organizations out there that do. Disability Rights and Southern Legal Counsel, and I often co-counsel with them. I'd suggest if you come up across things that you think are violating somebody's rights, that you contact one of those organizations. Palo has done federal cases with the Children's Legal Clinic at FSU. I mean, there are a lot of options out. Matt Dietz, he does them as well. They're not something that I ever take on by myself, because there's a reason that they say don't make a federal case of it, because it's like just the motion practice part of it alone is like you're now on document number 95 or something. It's a little crazy, but it's very effective, and I think in some ways in Florida the only way that we're ever going to get some decent level of services made for kids in particular. So there were a lot of questions about, let me get to this wait list because I forgot about it. So wait lists are A-OK in a certain level for the home and community-based service waiver programs. However, there are limits on that. The limits actually come from the Americans with Disabilities Act. So there's a case, the Olmstead case, and essentially what that says, I'm going to kind of mangle it probably, but it says if you're providing services to somebody with disabilities, you need to do this in the least restrictive setting. And so if otherwise you would be providing institutional services to this person, you need to look and see whether or not it's a reasonable accommodation to provide those services in a less restrictive setting, meaning a home or a licensed group home facility. Those cases, and that's a very, very powerful regulation and Supreme Court opinion, and it has resulted in things like forcing states to move people off of the wait list more quickly. It's resulted in actually forcing additional services from home and community-based service programs when they're not adequate to meet those needs, and that was a federal case that I just settled. Bear that in mind. I mean, even knowing about it, even mentioning the ADA kind of between, oh, doesn't that sounds like a little ADA problem, is powerful. You can get people to understand very quickly that you know that there are rights here that are being violated and that you want some sufficient correction to them in a short amount of time. Okay, provider questions. Someone asked how to request a second opinion from a different medical professional. So I had to look this up, but the federal regulations actually require that a second opinion must be a part of at least the managed care plans. You have to have the availability of a second opinion. So for any of you who have Sunshine or CMS, Magellan, the case manager for those MCOs should assist you in getting a second opinion. Has anyone had, what problems, yeah?
Second opinion outside circuit or in circuit, second opinion?
Second opinion, you mean outside of the plan versus inside of the plan? I think they can choose inside of the plan. I think in order to get out of network, and out of network is definitely something they have to provide. In fact, there's in the contract, they have to say in their enrollee handbook how you get out of network, how you get an out of network referral. Do any of you ever pull up the enrollee handbook for Sunshine Health or Magellan or CMS? They're all online. I look it up. You can use it to your advantage where possible. This is one case. I find from, at least from my experience with the long-term care program, which is in managed care, and Sunshine Health is a player in that as well, the case managers are very ill-informed as to what the services are that are covered, what their requirements are. Things like a second opinion are likely to go way under their radar. You likely will need to either use the contract that ACA has with the managed care to point out where the problem is, or their own enrollee handbook. Yes?
That was a question I submitted. Who would I do that with? Because if we have a toddler who's appearing to be severely bow-legged, the guardian recognizes this toddler is severely bow-legged, I'm only knowing that as a mom of a baby and a toddler, I would be calling incessantly to try and get my child seen by a orthopedic. The case manager is saying, well, we'll let the pediatrician look the next time. No, get the child in. Then I'm wondering, does that even make there be to issue a referral to begin with?
So that's a number of questions. So she was asking, if you didn't hear it, the example of a child who's bow-legged and wanting an orthopedic referral. That's not a second opinion. That's a referral to a specialist.
I've also had significant issues where I have ENTs, particularly ENTs or dental providers, stating that a child doesn't need maybe a hearing test or doesn't need dental work versus like my mom said, when I
Right.
actually I've had two children and those have had that looked at. And so the only way
So no, there is a definite requirement in their contract that, and like I said, there's a federal regulation that says you have to be able to get a second opinion. So you have to ask through the case manager. If the case manager said, I don't know what you're talking about, you got enough, you go up the ranks. You go, I want to talk to your supervisor. I want to talk to the freaking medical director. And then I would talk to I would have if you're not an attorney, have the guardian ad litem attorney or DCF attorney talk to the attorney for the health plan. That's often where I get things fixed.
I'm sorry, can you clarify when you're saying case manager, you're not talking.
I'm talking about the Sunshine Health case manager. Exactly. So here's the other option that you've got. And I strongly recommend you use it anytime you run across these problems where you're just stymied by the lack of information or no one's doing the referral. There is on the ACA website, you can find their complaint hub, and you can do an online complaint, or you can do you can call their. I always recommend doing it online because now you got it in writing, and they send you back a copy of it immediately. So that. You Google ACA. If anybody who tries to navigate the ACA website, oh my God, that's so crazy. If you type in a search, there's no way you're ever going to get anything like what you thought you were supposed to get. However, if you Google it first, you'll often get to where you're supposed to go. So if you Google ACA Complaint Hub, you'll typically first hit the complaint for managed care. Although you can do it for fee-for-service too. There is an ACA complaint for licensed facilities. Just make sure you're not using that one. Although I think even then they'll route it to the right place. Now, I'm not saying you'll get it fixed through that, but it is something that is automatically recorded, that they keep track of, and if there are multiple issues, they supposedly meet about it. I have had things fixed. Somebody typically will call you and ask you about it, and then you may never hear from them again. But I strongly recommend that everybody do it anyway. And I'm told by ACA to do it. I'll call up with a problem, and they'll say, can you please put this in the complaint hub too? So you're entitled to a second opinion. You can ask for a referral. I think more needs to be done with the primary care physicians. I think there's probably very little training with them. The PCPs really are supposed to be doing the referrals. And if you can establish any kind of communication with not necessarily the PCP, but somebody generous and lovely in their office, a nurse or an office manager, I think that's really where you're going to get the best results. They don't have a lot of time, and they, Medicaid is so bureaucratic for them too, that the more you can do on their behalf, the better. I sometimes even write letters based on the information they've given me and say, please edit, and and then we'll send that letter out, to ACA or Sunshine or whoever. Now, here's where we get into like really difficult provider problems, and I don't have a silver bullet answer for you. Two different questions. One is how to best access services from a therapy provider that is appropriately trained for our very traumatized youth. And why does Medicaid pay for therapists who only have an MSW and limited clinical experience? So part of the problem that you're dealing with is the rate that is paid providers. And not a lot of providers want to mess with the bureaucracy that is Medicaid for the rate that they are being paid. So they will often go to private insurance or other Medicare, any other program that is less annoying to deal with and provides higher rates. There are federal cases that deal with rates and not having a sufficient provider network. They're probably one of the most detailed data laden, lengthy cases that you could ever bring. I think Pediatric Society of Florida brought a similar case, and that went on for 10 years. They had like a 90-day trial or some bizarre thing like that. It's very, very difficult. The only thing that I know to do about provider rates is lobby the legislature. That sometimes helps. There is legislation, or there was an effort this session to try to raise rates for APD providers that have not been changed since 2003. They are losing nurses by the handful. I mean, worse than that. I mean, you can't find nurses for many APD clients anymore, and they're having to switch over to the long-term care program because managed care can pay a little higher. They can set their own rates. And they're not dealing with the level of bureaucracy that straight Medicaid requires. I mean, it's awful. There's insufficient behavior service providers. Nursing is bad even for straight Medicaid. You can't find certain APD services like companion. And then often when you're getting direct care services, the pay rate is so low, it's not even living wage. So you've got people that are working multiple jobs. They come to this one exhausted, and they're falling asleep or playing on their cell phone. There may be people that really did not do well in other types of employment, and they're also not doing well in this employment, which is pretty critical, dealing with children or people with developmental disabilities. I will tell you, though, that the Sunshine Health plan for child welfare has very specific language in the contract about requiring contracts to provide care planning for trauma-informed care tailored to the individual. They have to ensure that that there are primary care physicians with training and experience in treating children with behavioral health needs, that there is a formal training of network providers in the dependency system on trauma-informed care, and they have to employ a dedicated child welfare medical director to oversee the case management. They're supposed to provide initial training on trauma-informed care. They're supposed to do continuing training. Whether any of that is happening, I don't know. This is another place where if you're finding that the therapists that are being used are ineffective, I would try to work with your team to try to get a different referral. Once again, a PCP that is aware of the problem could be very useful in trying to ask for an out-of-network therapist. And you can document it. I mean, if you find that the care is not effective, document it, and then try to find somebody out-of-network that will take that case and seek an out-of-network therapist. Yeah, sure.
That was my question. Which is a great idea, and what I'm running into on a practical level, at least in my circuit with my kids, is so we're not satisfied with the providers that we're getting through that are being paid for, and so my judge says, you've got to do better. We come up with a provider that doesn't accept Medicaid, and she orders the CDC, which really she can't do, but they do it anyway. She orders the CDC to pay for this provider. So I guess what you're saying is, I guess I'm wondering, and then the CDC gets all cranky about having to pay out of pocket, and when it should be covered by the child's insurance. I guess it just based on what you're saying, I'm wondering why the CDC isn't doing exactly what you said, connecting with the primary care physician to get an out-of-network referral, so they don't have to get cranky about having to pay for.
So I've often found that the managed care organizations will tell people that things can't be done or services aren't offered when they're not correct about that. And so if you rely on that information, you're probably like, well, okay, I guess I just have to get it through the CBC. and it's not true. Now, I'll also tell you that the hardest cases I've had ever are involving managed care organizations, because they're large organizations. They know that if they lose on small cases, that it'll be a domino effect. So they bring experts in to avoid paying $1 a box more for brand name diapers as opposed to generic diapers that leak. I mean, I think ACA is taking a stronger position maybe to try to control that, but ACA's limited in what they can do. I mean, look at the number of people that are now in managed care. What's ACA going to do to oversee that level of participation? What is it? I'm guessing it's like over 1 million. So yeah, to me, the provider issues and the lack of providers and the ineffectiveness of providers is just one of the hardest that I face, and you almost have to just like throw everything at it and see if anything sticks, which is kind of my method of operation in any event. There was something in your question, though, that spurred me to think of something. It'll come back to me, hopefully. One of the questions was how to help providers so they don't quit taking Medicaid. I don't know how to do it. I don't know how to keep people from entering this system that's so frustrating and pays so low when they have opportunities, and they're working with paying for their family and houses and mortgages and everything else, and they're offered opportunities outside of Medicaid for twice what they're being paid in Medicaid. I think that we all have to be better about working legislatively. And I think that's probably true now on state and federal, that we need to be paying attention. I know I wasn't, if it wasn't in my specific area. And I also didn't ever, I felt like I take the laws that people give me and then I try to figure out how to advocate using those laws. But now what I'm seeing is oftentimes it's the law that's the problem. And I don't know any way to change that. I'm not a lobbyist, but I'm beginning to feel like I need to be more cognizant of that and more involved in the process. And it's not making me happy, but it is a problem. I heard this morning that I think that the rate increase for APD is likely not to have been passed. I mean, how awful is that you can't get a rate increase from 2003 for the people that are the most vulnerable in our state?
What is APD?
What?
What is APD?
APD is the Agency for Persons with Disabilities, and that's the program that any of your children who have developmental disabilities will probably get in their adulthood the most support and the ability to live independently as possible. But they're not, that APD is not alone. The service, the rates for pay with regular Medicaid are very similar, and they're just not enough. I mean, a lot of the providers that I work with are so dedicated and so, they're willing to do the sacrifices to work for low pay, but even they get hit with bureaucratic idiocies that make them just finally say, forget it. I've looked at the provider contracts with state plan and with APD, and I'm like, who put a gun to your head and made you sign this? Because you have no rights at all, none. And those people are just operating on a prayer. The right to terminate the contract is just, you can have no reason at all. The only reason that you can fight it really is retaliation or discrimination. I don't know how we're ever going to get good providers under the system that we're operating under. I've been involved in some fraud claims where small providers were forced to repay the little that they got paid because they didn't have a checkbox that in one of their forms that they should have had. There was no question that the service was provided. There was no question that the service was provided in a fashion that was acceptable, but they didn't have the checkbox. So providers have been forced out for things like that. We need to start looking at what's happening to the system itself by the regulations that are being imposed and how they're being imposed. God, I sounded like a Republican. But how do you challenge? Let's say that you're working with Sunshine Health and a service is being recommended and Sunshine Health won't provide it. Are people getting notices for that, saying, I'm not, a notice of adverse benefit determination? Are they just, the case manager is just saying, we don't offer it? The case manager is just saying, we don't offer it? Okay, big problem. You need to say, I want you to submit the request, and you need to put it in writing, and then there is a time frame that they must respond, and it's fairly short. I think they have to respond within 7 days and make a decision within 14 unless they're asking for more documents, and then they can kind of push it out a little. And then if they don't respond even then, that's the one time that you can now go straight into a fair hearing, is if you don't have, you have not gotten an effective response within a reasonable time from managed care. Back that up. So the way the system now works for challenges is you have to exhaust your appeal with the managed care organization. That's a federal requirement. You can't blame the state for that one. I'd like to, but you can't. So now, anytime you have a denial, you got a little sheet of paper and they're not giving you what you want, you have to ask for an appeal internally. And what that means is that a different clinical person, not under the supervision of the first person that made the decision, is supposed to look at it again. And you can submit new evidence and whatever. I've never had a situation where they changed their mind, ever. And I've often had the same person make the decision again, which is a violation of federal regulations, and it's a violation of due process, so it's got a lot going for it. Once you get their adverse decision on appeal, that's when you can now ask for a fair hearing, and they're now all going to the ACA, new ACA, Office of Appeal Hearings. Like shiny, brand spanking new. It's up and running March the 1st. And they've got a set of rules that they proposed, and I think they're final, so you need to kind of look at those. They're not terrible, but they definitely need some work. Anytime you've got a case where children are getting benefits and the benefits are being terminated or reduced, you have the ability to ask that those services continue. And you have to do it within 10 days of the date of the letter. And do it in writing. Yes?
Have you seen success with fair hearings? I've always been a little bit concerned that, okay, you as an agency are appointing this hearing officer. How objective are we really being in whatever results we're getting from fair hearings? Have you found them to be successful?
No. Sometimes yes. Yeah, I've gotten favorable results in a fair hearing. I fight like hell not to go to a fair hearing. I do the most intensive settlement negotiations that you can imagine. I send memos. I ask about getting other evaluations. I do whatever I can not to end up giving it to someone who's I think is a little biased in favor of the state. One of the things that I would love to see is some great beneficent advocacy organization that would post redacted hearing final orders. I have on my own, as part of the big federal case that I just did, we got through public records requests, we got them, and we had to pay, because you have to pay the costs that they have for redacting. And in the long-term care program, over the 2 years it was running, we calculated that I think less than 15% were favorable for a petitioner. And most of those were on very small sorts of things. And one of them was something that was so egregious it looked like the person would have died without it. But they were almost uniformly in favor of the agency or the managed care organization. In other states, that in New York has a much more transparent system, and the the results are actually tend to be more in favor of the petitioner. So that's not, I don't think that's normal or fair. Now, what's going to happen with ACA? I don't know. The mindset that I'm running across after this case that I did was that they are going to try to do a better job of ride and herd on the managed care organizations. I think that's just something we'll have to see. I do every fair hearing as if it's going to be appealed, so I just keep a good record, and then appeal it. I'm not all that successful on appeals either, so that's probably not helpful. But at least they know that I'm determined, which counts for something, I think. So how long should a child have to wait to see a provider? And this is another thing that's in the contracts with any managed care organization, not just Sunshine, not just child welfare. Their time access standards. For urgent care, it should be within 1 day of the request. For sick care, within 1 week of the request. For well care, within 1 month of the request. And then it says the managed care plan shall authorize enrollee referrals for EPSDT services to appropriate providers within 4 weeks of these examinations for further assessment and treatment of conditions found during the examination. And then they have to ensure that the referral appointment is scheduled within 6 months of the initial examination, or within the time frames that I just told you about, if they're sick, or need urgent care. I'm not going to say that these contracts are really accessible, but once you pull them up, there are portions of the contract you can pull out very clearly. And what I do is I cut and paste the parts that I know I'm going to need to see again and put them in a separate document. And then I just pull them up when I'm dealing with them. I don't know any other way to deal with the managed care plans than to use their own contracts, their own handbooks against them. Because they are not consistently telling people accurate information based on what's required of them. Now, that being said, I've had great experiences with some Sunshine Health case managers who were like all over it and very actively involved in cases and getting appropriate services, and then even cases where therapies were not being done in a way that was effective, and then the case manager switched the kid. So it can be done. The system can work, but it's not. Question? Agency for Health Care Administration. I apologize. So the key players in Medicaid are the Agency for Health Care Administration, which oversees, is the single agency responsible for all Medicaid. So if that's all you remember and you're having a Medicaid problem, you should contact ACA, and they're supposed to be able to help you. Under ACA are other agencies that deal with different aspects of Medicaid. The Department of Children and Families does all the eligibility, particularly financial eligibility criteria. The Agency for Persons with Disabilities is the agency that runs the Medicaid program that provides home and community-based services to people with developmental disabilities. And that requires a separate application. There's a separate process for getting on that, but the statute now says that if you've got a child that is eligible and they're placed into permanency, at that point they are now the second category priority to be enrolled. And I've not ever had a case where they had to wait because of that. They were instantly placed into APD at permanency. The same is true for children that are in the system and they're 18 but under 22 and they're in extended foster care, and the decision is made that they need both extended foster care and services through APD, or they refuse extended foster care and they need services through APD. There are still, that whole legislation was designed to end disputes between APD and DCF as to who was responsible, but my understanding is that it really hasn't. That there's still a lot of dispute going on, which leads me to mention something that I ran across years ago when I had a case that was just awful, where everybody was saying somebody else needed to provide service. Everyone understood this kid needs, this crap load of service, but everyone was saying someone else had to provide it. So I did my little googly thing, and I found something that was then called the Champion Agreement. And I'm like, oh, cool. It's an interagency agreement with DCF and APD and ACA, all these players, and the whole thing is designed so that you can take cases where there's a kid that needs services from multiple agencies, and this crack team gets together and sorts it all out, and your kid gets the services. Does that sound great? Yes. So no one knew how it worked. I called all the district. I probably spent hours until finally I ended up just calling the executive directors of the agencies involved. And they appeared to actually know because they had signed it, so their signature was on the thing, so at least they had that much knowledge of it. And I was able to use that to get what I needed for the kid. I don't know if anybody else has ever used it in its history, but it exists. It's not the Champion Agreement anymore, but it's an interagency agreement between ACA, APD, Department of Children and Families, DJJ, Department of Education, so you can actually get people from the schools in too. Wow, that's so neat. Department of Health, Guardian Ad Litem, and Florida's Office of Early Learning to coordinate services for children served by more than one agency. Has anyone ever used this? Has anyone ever heard of this? Okay, so this version that it's long, it's got all sorts of cool stuff in it, was signed in 2012, and it's good until July 1st, 2017. I emailed the general counsel for APD and ACA to say, hey, what's up with this? And I attached a copy because I figured they probably wouldn't know about it. And I did get a response from APD that said they are working on a new version of this. But the problem that I see with it is that there's supposed to be a local team, and then if the local team can't figure it out, there's supposed to be a regional team, and if the regional team can't figure it out, there's supposed to be a state team. But all of them say that this agreement just says that the costs are to be, quote, shared. There's a table at the back that sort of tries to describe the different services that each agency is responsible for, but that's what they're all arguing about anyway. I mean, I'm going to suggest that they have binding arbitration, that if you can't figure it out, give the services to the kid, and then all of you go off in a room together with an arbitrator, and the arbitrator decides, okay, DCF, you pay for this, and APD, you pay for that. Otherwise, I think we're all stuck with the problem that we have every day. We've got a child that needs services and a whole bunch of state agencies all saying it's not out of my pot. But I strongly recommend that you try to push to use this interagency agreement. It exists. I don't think it's been used by almost anyone. It is online, and I ran across this after I had to submit my materials, or I would have put it in. It is being worked on, so it's going to be, supposedly there'll be a new one July the 1st. And I'm going to email the directors and say, I want this, if you're serious about actually having an agreement that works with children that aren't getting the services they need because you guys keep fighting, here's what I think needs to be in this. And I'd like to see a copy of it in draft form. So you guys can get with me if I'm successful. I'll try to get the word out. But that's the only way that we're going to get what we need is once the state agencies stop. I remember when I did my first dependency case where I was an attorney ad litem for a special needs kid, and I sat there watching all these people talking, and I looked at the magistrate and I said, all we're doing is arbitrating disputes between agency about who pays for what this kid needs, isn't it? And she said, that's exactly what we're doing every day, day in, day out. That's no way to help kids. What time is it? We're getting close to the end. Does anybody have any other questions? I hate to leave on that sad note. Success story. Oh, so I've had a lot of success stories, and I often don't have time to celebrate them. Do you guys find this is true? You get like a great success, and you go, yay, and then you get a phone call, and it's like, shit, So you just don't, it's like I need to like stop and have champagne. I don't like champagne, but I should have it anyway. So a group of us, I was lead counsel, Southern Legal Counsel and Disability Rights Florida, started getting cases from managed care in this long-term care program that provides home and community-based services for people age 18 who are disabled and people who are elderly. So there are like 48,000 people in the state that get these services. And they all got moved into managed care, and we started seeing these cases come in that were just really horrifying. One of the client who was the named plaintiff of mine was a young woman who was on a ventilator, left a hospital on a ventilator to go home, and the managed care organization said, we will provide you with an hour a day of a nurse, 5 days a week, and no respiratory therapy because it's not a covered service, and we don't provide private duty nursing. And when the mom, who was an LPN, got a hold of me several months later, she had been providing 24-hour care to her daughter, sleeping on the floor next to her bed, wearing a sanitary pad because she couldn't go to the bathroom half the time when she needed to be with her daughter, and had not showered or slept more than 2 hours at a stretch. We had that case, and that case got fixed marginally, so that the woman could shower. She called me the weekend she showered and said, I just took a shower. I can't tell you how amazing that was. I got that fixed really quick by threatening an emergency, a temporary restraining order. And then we started seeing more cases that were not that bad but close to it. And I got together with these other advocacy organizations, and we put together an ADA Olmstead lawsuit that was against ACA for failure to appropriately provide standards for the managed care organizations, monitor or implement the program. And we had an amazing judge, and he ruled against them on a motion to dismiss and a very good opinion. We went through a crap load of discovery. I think the Bates numbers were up to, I don't know, like 14,000 and something pages. And then ultimately we ended up with an excellent settlement. We now have a handbook in place for that program. There were changes made to the contract. There's changes in how they're monitored and surveyed. All of that being said, nothing will change without a culture change in the managed care organizations and a constant set of eyes. And I think that's true not just for the long-term care program, but for all the managed care organizations themselves. What you're fighting is they're getting a very limited amount of money, and they're also expected to make a profit, most of them, by their shareholders. So it's an extra layer of administration. It's not enough money, and there's a profit motive. It's not a great combination. Yes.
This is a practical question. How do you get paid? How do you get paid?
Oh, that's a question you should ask my husband, who does all the financials. No, I have. The kind of interesting thing about anyone who's enrolled on a waiver program is that only the income and assets of that person, even if they're a child, count toward their eligibility onto Medicaid. So often, family members are not financially strapped, and they can pay for a private attorney. In federal cases, the cases, ADA cases, and any action under the Medicaid Act are prevailing party fees. And in settlement, I do a pretty decent job of pushing to get fees, because we're the ones who are enforcing, and that's the whole reason that system exists. So I'm not ashamed to ask for fees. And I do a lot of pro bono, and I don't know that this is an area of law that many people could go in privately. I just had a passion for it and wanted to see if it would work.
Isn't that the point, though? So it's, when you're talking about people doing personal injury or, they're making a huge amount of money. So there's a drive for that. So this particular area is left to people who have a passion, who either have somebody who can help support them, personally. But, I think if more people at least took on some of it to hold them accountable, that's part of why I'm here. I can't do it for free all the time, but there has to be a challenge. That they're not afraid. I know some of the hearing officers and stuff, and I know some of the agency background, and they know that a lot of these petitioners can't get an attorney.
Right, and you can see that when you read these cases over and over and over again. Oftentimes people lose solely on the ground that they don't understand that hearsay, even though you can use hearsay to corroborate other evidence, you can't use it to make a decision on. So they'll say, I gave them 8,000 documents that show that this person needs this service, but without a single person there to testify that that's a medical person, you're screwed. And it's those are the sorts of things that shouldn't be happening. And one of the things when I was arguing about fair hearing rules was to put something in that would give hearing officers the authority to assist in that regard for pro se petitioners. There is something in there now that allows a hearing officer to ask for an independent examination, and they added that to the rules. So I don't know if it's going to change, but certainly with the managed care organizations, it's a big uphill battle. I mean, I'll be on phone status conference calls, and if any of you have ever been involved in them, that's the two attorneys talking to the hearing officer, like, yeah, we're ready to set a hearing, or no, we'd like another, 30 days or something. That's it. I've been on those phone status calls. Well, there'll be 7 people from Sunshine Health, including 2 medical directors. I mean, do they not have other things to do? It's they take this stuff very, very seriously. And we're going to have to do the same. And that's why I suggest, even if you don't want to do these big cases, and who does? I mean, there are not many of us that want to tackle them. There are people that do. Just issue spot. And call me, call Southern Legal, call Disability Rights. All of us want to know. But there are people out there trying to watch, but we don't have enough eyes. If you guys could be the eyes, I would want, that would be so helpful. So thank you all for what you do. Yay.